Everybody, welcome back. My name's Glenn. This is Legally Speaking. Today I want to talk about what happens when you die without a will. In Illinois, when somebody passes away and they don't have a will, it's called passing away intestate, or intestate succession is the name of the process that you go through. And what that means is that the laws of the state of Illinois dictate what happens to your assets, and they have rules of descent and of distribution in the statute that covers that. So, for instance, if somebody dies, they don't have a will, the statute says that if there's a surviving spouse, then that spouse would get everything. If there's a surviving spouse and children, then the spouse would get half and the children would get half. If there is no surviving spouse but children, then the children would get everything. And if there's no surviving spouse and no children, it gets extremely complicated after that. So those may or may not be the way that you want your assets to pass. More than likely, it is not. For instance, if I didn't have a will, my spouse would get half, my kids would get half. My children are minors, so whatever they stood to inherit would become theirs outright at age 18. And that's not necessarily something that I want. So I've done some planning to make sure that that's not the case, so that there's some more checks and balances on that, so that they don't frivolously spend those monies that they inherit. They turned 18 and weren't all that responsible. So that can get pretty complicated, but there are some pretty simple avenues that you can pursue to make sure that doesn't happen. If we can be of assistance with your estate planning, be happy to talk to you. Our telephone number is 217-735-1234. Look forward to talking with you. Thank you.